The Constitutional Court has interpreted that a nullification does not amount to a disqualification when analyzing Article 72 of the Constitution. This was through the majority judgment delivered by Judge Palan Mulonda, who stated that a vacancy in the National Assembly caused by a nullification does not deter an individual from recontesting in the said seat. This is in a matter where former Lusaka Province Minister Bowman and former Foreign Affairs Minister Joseph Malanji had sought constitutional interpretation over their disqualification from contesting parliamentary by-elections on the Copper Belt. The two wanted the Constitutional Court to determine the legality of the Electoral Commission of Zambia (ECZ's) decision to prevent them from recontesting elections. The Kwacha and Kabushi seats fell vacant last month after the Constitutional Court upheld the High Court's decision to annul the elections of Mr. Malanji and Mr. Lusambo during the 12th August 2021 general elections. Mr. Lusambo's electoral victory was annulled on ground that he engaged in bribery and violence, while his counterpart was found not to have a grade 12 certificate. However, a day before filing of the nominations for the by-elections, Electoral Commission of Zambia (ECZ) issued a statement announcing that it would not accept nominations from any of the candidates who caused a vacancy in the National Assembly, and the nomination papers for Mr. Lusambo and Mr. Malanji were rejected. And for that, they went to the Constitutional Court and raised 4 issues, among them for the court to determine whether ECZ's decision to stop them from participating in the upcoming by-elections is illegal, null and void, and also wanted the court to determine whether they are eligible to contest ECZ's by-elections, and further, if fresh nominations could be conducted. Lastly, they wanted an explanation on what was meant by causing a vacancy in the National Assembly, arguing that ECZ has no jurisdiction to interpret the law or to disqualify a candidate who has lost. And the panel of 5 judges, after hearing arguments from the State Electoral Commission of Zambia (ECZ) and lawyers representing Mr. Lusambo and Mr. Malanji, interpreted that nullification does not amount to a disqualification. And making submissions, the Attorney General Chambers asked the court to dismiss the matter on ground that the originating summon was a wrong mode of seeking relief in the matter filed by Mr. Lusambo and Mr. Malanji. And on the other hand, Solicitor General Masha Muchende reiterated that the matter must be entirely dismissed as it was not properly before the Constitutional Court on account of a wrong mode of commencement.
ECZ chose to ignore the guidance that was given by the court in that case and made their own decision. They have no power to do so. The best they should have done is tell the people of Zambia to say, we do not understand this clause, we are going to ask for an interpretation at the Constitutional Court in the manner that we did. Well, the court has said nullification is not disqualification. Therefore, those whose seats were nullified and were not expressly disqualified by the court are eligible to stand. So Bowman and Joseph Malanji are eligible to stand.
What we do now is to call upon the ECZ to do what the Constitutional Court has directed, to make sure that they put Bowman, Lusambo, and Malanji back on the ballot papers for Kabushi and Kwacha constituencies, respectively.
Margaret Chota, MUVI TV News in Lusaka.